want to welcome the witnesses as well, and let's talk a little bit about brand reputation, if we may. We all know that how important brand reputation is. As Warren Buffett has said, it takes 20 years to build a brand and 5 minutes to destroy it. Let me start out with Mr. Patel, the question, sir. In 2020, Unilever paused all social media advertising because the environment had become very polarized and unhelpful to its brand. Is that correct?
Yes, sir.
Let me say consumers agree with you that, in fact, 82% of consumers also feel that it is important that the content surrounding online ads be appropriate. And Mr. Chairman, I'm going to submit for the record an article titled Brand Safety, What Do Consumers Consider to be Inappropriate Content? So, Mr. Patel, I'm going to ask again, Unilever paused advertising on both conservative and liberal channels and did not specifically target conservative platforms or content creators. Is that correct? And that's for 2020.
Yes, sir. We pulled all our advertising from all assets.
So, Mr. Patel, it sounds like this is more of a pure business decision and not a messaging crusade on your part. Would you agree with that?
No, we did what was felt was best for our brands.
Business decision.
Yes, sir.
And Mr. Patel, you've testified that Unilever, you make decisions to advertise independently. Is that correct?
Yes, sir. We make our investments on what's right for our brands. And
no group, including GARM, dictates or approves where Unilever spends its advertising dollars. Is that correct?
100%. Unilever makes its own decisions.
And no group directs Unilever to avoid any platform or creator. Is that correct?
Yes, sir.
So, Mr. Patel, members of GARM can come and go freely like X, formerly Twitter, have done. Is that correct?
GARM is a voluntary organization.
Okay. Professor Waller, if I may, some on this committee have suggested that members of GARM have colluded to harm competition by boycotting certain platforms or speakers. Don't businesses have the fundamental right to choose how and where they spend their advertising dollars?
That is correct.
And it's clear from Mr. Patel's answers and the public documents that there is no collusion. Would you agree with that?
I can only say as a matter of, I have not read the committee's report, and based on publicly available information, I'm seeing a discussion of unilateral decisions on how to do business, which is the purview of each company, and you simply need more. You need more, even if other firms are doing similar or even identical decisions. The law is clear that you need something that shows that they're acting in a way together rather than independent. And I see you have an element of antitrust violation.
Well,
chart
what
behind
you have behind me, sir, Mr. Waller, is a chart of the 3 elements, the mandatory elements of a Sherman Act Section 1 violation. You need to prove all 3 elements. So, Mr. Waller, let me ask you, are you aware of any agreement among the competitors to boycott or collude?
Well, I have no personal agreement, but I'm not hearing anything today that suggests that. And in the absence of an agreement, I can just say there is no Section 1 violation.
So if there's no agreement, there can't be a Section 1 antitrust violation.
That is true.
So there's no antitrust violation.
If there's no agreement, there's no Section 1. And then there are other requirements that your chart has, 2 additional requirements. You have to show an unreasonable harm to competition. There's one, in addition, I would suggest that if the firms involved have a legitimate business justification for what they do, that is often enough to avoid a violation, even if there were an agreement.
That's a lot. Thank you very much.